a senior attorney here at Wang Law Office, and you are watching the AM Show, our immigration question and answer show.
Hi, my name is Ariel. I'm the host, also a senior paralegal at Wang Law Office. Our show is going to start every Friday at 11 a.m. EST, 8 a.m. PST.
So here at the AM Show, we answer all your immigration questions. We get our questions from line and email and YouTube, and we encourage everyone to send them in. Every week, we do a different topic, and this week, we're going to talk about what happens while you're waiting for your case, given all these backlogs and delays. Should someone be doing something while they're waiting? That's all that we're going to talk about today.
Victor, before we actually start today's topic, can you introduce a little bit on your own background?
Sure. For those who have not met me yet, my name is Victor Manibo. Again, I'm a senior attorney here at Wang Law Office. I've been with the firm for 10 years. I've been a lawyer for 12 years, and I graduated from Cardozo School of Law here in New York. I'm licensed in New York and New Jersey, and I mostly do immigration litigation, meaning helping people defend them from ICE if they're in immigration court about to be deported. I also do immigration applications, meaning helping people to apply for legal status to be in the United States. And finally, I do a little bit of crimmigration. That's a mix of criminal law and immigration.
So, Victor, how long are the backlog right now?
Backlogs in immigration court are pretty bad right now. There are 1.3 million cases that are backlogged, and we only have several hundred immigration judges. This means years and years of waiting in between immigration court dates, or like to even get your first immigration court date. During the COVID years, this got a little bit worse because courts were closed and no hearings were getting done. So every court is different because the immigration courts are spread out all over the country, and some places have more cases than others because that's where cases start and that's where people live. So court loads are different. But with New York and California, the immigration courts there are some of the busiest in the country, and the wait times can be, several years. I have hearings that are, the wait time in between is like 3 years. And, because of those delays, because of that gap, a lot of things could happen, and those things can be good or bad. And that's why we're talking about this topic today.
So I want to know, is there a way to request immigration court to get an earlier hearing date so I don't have to wait that long?
Sure, there is a way. You can file a motion to advance and ask the immigration judge to give you an earlier hearing date. If, let's say, you're given a date in like 2025, which is, kind of common. But to convince the immigration judge to move an earlier hearing date, you usually have to have a strong reason. Usually it's a medical reason. Maybe you are not in the best health, or somebody related to the case is not in the best of health, and you should have the hearing sooner before somebody is unable to show up in immigration court, or before somebody dies. And because this is a motion, it has to be approved by the immigration judge. The judge has to be convinced that an earlier date is better. And sometimes even if an immigration judge wants to grant you an earlier date, they might not be able to because there's just no opening in their calendars.
So why are the delays bad?
Delays are bad because a lot of things can happen in a matter of months, and especially in a matter of years. Changes in the law can happen. Presidents change, and we saw how during the Trump years, the laws changed for the worse. So if your case is delayed and there's a new law that affects your case, that could mean that you're not eligible for certain reliefs anymore, right? Your immigration judge might change because immigration judges, they get sick, they retire, they die. That could be bad for your case, especially because if you get an immigration judge, they're not familiar with your case, and you might have to start things all over again, causing more delay. Your own life might change. You might move to a different place. Your relationships with your family might change and affect your reliefs if you're applying for certain application. For example, you could get divorced, or your spouse might die, and that could affect any family-based petitions. You might have children who grow up and become 21, for example, and they might not be able to be derivative beneficiaries in your application anymore. So all these changes can happen. The longer that your case is delayed, the higher the probability that something will change in your life. Specifically with immigration court, because you're putting up a case in front of a judge, you could lose access to documents, access to evidence. You could lose witnesses. Your witnesses might move, might not be willing to appear in immigration court anymore to testify for you. And DHS will also have a longer time to build a case against you to try and get you removed. So again, the longer your case is pending, the more these things can happen, and most of these things are bad.
So is that possible that the delay would be good for me?
In some cases, delay could be good. For example, you might become eligible for new relief that you weren't eligible to before. You might have a U.S. citizen kid who turns 21 who can now petition for you, and maybe you don't have to go through with asylum anymore. That could change the strategy of your immigration court case, and that could be good for you. Sometimes new laws could come up, and you might be eligible for new release. But even though there is a possibility that good things can also happen during delay, that's very rare, and those are fewer circumstances. And in general, you should just want your case to be resolved sooner rather than later for your own peace of mind. So you can settle like, okay, now I have status, or like now I can know what to do next with my life.
Yes, and of course, you can follow us on any of social media, maybe YouTube, Line, or WeChat for the newest law or policy to see if there's anything changed.
Yes.
If I'm waiting several years, should I do anything when waiting?
First, you have to make sure that you're already regularly communicating with your lawyer. A good lawyer will update you on their own, but it doesn't hurt to check up with your lawyer once in a while. Don't do it too often, but just, say, hey, did anything new happen? Are we just waiting, etc. Just to make sure that you're not missing anything. A good lawyer will also tell you if you should be doing something while you wait, because this is time that you could be using to improve your chances of success.
Yeah, and I asked if your case, we decide what to do. We're going to tell you maybe get a document or do whatever is good for your case.
Right.
So can you give me some example?
Yeah. So for example, if you're applying for certain relief applications, it might help to be preparing for your application package for your individual hearing while you're waiting. For example, if you're applying for cancellation of removal, you need to provide proof that you've been in the United States continuously, a physical presence for a continuous 10 years or more. So your lawyer might instruct you to keep gathering all those documents while you wait, and not just, wait. Maybe too, the delay is not that far off. Maybe the delay is only a few months, and your lawyer might ask you to start thinking about your testimony and prepare you for your testimony for your individual hearing. So these are steps that a lawyer could suggest that you need to take to prepare, even though the hearing is still far away.
So it is not just waiting for a hearing date, right?
No, of course not. You should always think about ways how you can be better prepared for your next hearing, how you can maximize the chance of your success. A good lawyer will also know how to tell you this so that you're not scrambling last minute, and you can get more documents and proof to support your case.
So what if the things in my life change when I'm waiting for a hearing date?
Yeah, things in your life could change, like I mentioned, divorce and death, and this could affect your reliefs or the strategy for your case. Or your children could also grow old, and that could be good or bad. It could be bad if they're a beneficiary and they don't count as children anymore if they become 21, or if they become 21, they might be able to be considered adults who can petition for you, right? And anyway, all of these changes, whether good or bad, have the potential to impact your reliefs and your strategy. So if these things happen, be proactive and tell your lawyer right away. Your lawyer might already know this, but it won't hurt to remind them that, hey, by the way, my child is turning 21. Or, you might not tell your lawyer that you got divorced, because, maybe you're ashamed or maybe you're still hurt, but it will impact your immigration case in some circumstances. So you should tell your lawyer. That's not something your lawyer wouldn't really know unless you tell them.
Yeah, so what if I move?
If you move residences, technically within 5 days, you're required to let immigration court know about your new address. But that might not always be practical because that's just like 5 days, right? But just do it as soon as possible, because if you don't change your address, the court might send notices to your old address. And if you don't get them, you're at risk of not showing up for court, and then you get an in absentia order. If you have a lawyer, that's less likely because your lawyer will get the notices and will let you know. If you have a good lawyer, right? But bottom line is you should let the court know, and you should let your lawyer know. Your lawyer hopefully will know right away to change the address with the court and file the necessary paperwork.
Yeah, we also checking the hearing date for our client. That is a good lawyer to do.
Yeah.
So what if I want to go back to my home, maybe China?
If you are in immigration proceedings and then you decide, oh, I just want to go home, you can't just leave, okay? If you have pending proceedings, you're still under an obligation to show up to court for your next hearing. And if you don't, you might get an in absentia order. So you can't just go on a plane and leave and say okay, I really give up, You should notify the court. You should notify your lawyer. You might be able to get voluntary departure. You might be able to work something out with DHS, because you can't just avoid going to immigration court by going back home and giving up, especially since you might change your mind later on and you might want to come back. You might want to get reliefs for yourself or your family down the line. And if you have an in absentia order, that's going to make it complicated or impossible.
Can I just sue the court to get an earlier hearing date?
You might have heard of mandamus and suing government agencies to speed things along. This is not advisable in immigration court and with the BIA. So my quick answer is no, don't do mandamus for our immigration courts. For USCIS, yes, and it's usually successful, and we're going to talk about that more later.
Can I move my case to another court that is not backlogged?
First of all, it's hard to know which courts are backlogged or not because they're all backlogged. Some of them are just more backlogged than others, right? But also, second, moving courts requires a good reason. You can't just ask a court, hey, I want to move my case to some other state because it's faster there. You have to give the judge a good reason to move your case, and it's usually because maybe you yourself moved or somebody connected to the case has moved to a different location, or maybe your witnesses are in a different location, and those are good reasons to move a case to another immigration court. But just a backlog is not going to be a good reason. It's not going to be approved by the immigration judge if that's the basis of your request.
Can I work when waiting?
That depends. If you have a pending asylum application or adjustment of status or cancellation of removal, you might be able to get an employment authorization document, an EAD card, a work permit, while you're waiting for the immigration court to get to your case and decide it. This is a separate application with USCIS. There are several steps that you need to take before you get your work authorization. But yes, it is possible. However, if you don't have status and if you don't have the EAD, if it's not approved, then you are unauthorized to work.
What about if my case is in BIA? What do I need to do?
With the BIA, it's slightly different because there are no future hearings. You're just waiting for a decision on your appeal. There's no case, so you're not waiting for witnesses. You don't have DHS building a case against you, and there's no immigration judge who might retire or die. But there could still be changes to your case that might affect your appeal or might affect your reliefs. So always notify your lawyer of any changes in your life. If you move, also notify your lawyer because they have to let the BIA know that you moved.
So we just talked about immigration court. How about USCIS? What is the backlog?
Okay, so the backlog with USCIS is a little bit worse. It's 8.8 million cases are backlogged overall. That includes simple applications and more complicated applications, and that means that's 8.8 million all over the country. USCIS has a ton of field offices, and they're all backlogged. And the backlog differs per field office, and it differs depending on the type of application. We're going to put down a link here below so that you can go to the USCIS website and check processing times for certain field offices and for certain applications. But these are just estimates. They're not 100% accurate. It's just meant to give you an idea of how long the wait time is for applications. For some of these, it can be 5 years or more. Some of them are shorter, but a lot of them are really long.
Is that backlog different from the priority date?
Yes, the priority date is specific to immigrant visa applications or green card applications. And the priority date is about the wait time until the petition becomes current. We've talked about this in a previous YouTube show. You can go view that. But for example, if you're waiting on a petition from a green card parent, there might be a 7-year wait time until the priority date becomes current. So after that 7 years, then you can file your green card application. And because of the backlog and the delays, that adjustment of green card application might take another 2 years plus. So yeah, the backlog with USCIS is different from the priority date.
If I file my application at a different field office, is that going to be faster?
If you look at the processing times on USCIS, some field offices might be a little faster than others. But again, these are just estimates. We never really know which field offices are faster or not. And more importantly, you can't just send your application to any field office that you want. USCIS assigns field offices depending on where you live. If you live, for example, in New York, you have to send your applications to a particular address. You can't just send them to like this other field office in California, for example. If you do, your application is going to be rejected. It all depends on where you live, and that's also how they assign where your interview will be. So no, you can't just file it at the fastest field office.
Why are the delays bad?
With USCIS, the delays are bad for the same reasons that they're bad in immigration court. Changes in law can happen, and they're not always good. Your life can change, and not always for the better. Especially, we see a lot of marriage petitions that like become ineligible because of divorce or death. There are some exceptions to this that we've talked about in prior YouTube videos. But again, in general, you might not get the green card anymore. You might not get the petition approved anymore if you're no longer with that spouse, right? So these changes, they're all bad. So the longer that your case is pending, the higher the likelihood that these things happen, and you want to avoid that.
Is that possible the delay would be good for me?
Same with immigration court. Some changes during delays might be good, pertaining to children, which I talked about before. One of your kids might be grown up enough to be considered an adult and petition for you, then that means you can apply for a new thing with USCIS, right? And there might be good new laws that could come out that will impact how your current case is decided. But again, you can't count on these things happening. Generally, you will want, or you should prefer, for your application or your petition to be decided right away, just for your peace of mind.
Yeah, just reminding again, we keeping you guys updated for any law and policy. Just follow us. So what should I do when waiting for USCIS to decide my case?
While you're waiting, your lawyer should be communicating with you, but also, again, you could be proactive and communicate with your lawyer. Call them once in a while just to see, hey, is anything going on with your case? Your lawyer will also tell you if you should be doing other things while you wait, like gathering documents that you might need for the interview. And most critically, a good lawyer will update you if there are any notices from USCIS. Unlike immigration court, where you might just be waiting for a hearing date, with USCIS, while you're waiting, you might get a request for evidence. You might get a notice of intent to deny, and you have to respond to them, and they have deadlines. And if you don't, then your application or petition could be denied. You might have to update documents with USCIS. So During this wait time, things could still happen. You're not just waiting for the final decision. USCIS might ask of things for you, and your lawyer will know to update you for that, but it doesn't hurt to also just check, especially if the wait time has been like really long.
Yeah, like us, we always checking the case regularly to make sure we and our client knows what happened on the case right now. So can you give me some example?
Again, so if you get a request for evidence, a notice of intent to deny, you should respond to that. Your lawyer will tell you to respond to that. So, you can't just wait for a decision. You actually have to do something when you get these notices, right? If your application or petition has an interview, you should also be preparing for that interview. You might have to bring documents to that interview. You might have to update documents for that interview, like your medical exam or any financial documents. Your lawyer will advise you about those things, and you should be ready to get those documents and update those documents in time for your interview.
So I'm not just waiting for a day
No,
for the interview or decision, right?
no.
So what if the things in my life change when I'm waiting for those interview or decision?
Divorce or death, or you have a new child, or your child becomes an adult. Again, all of these things can affect your beliefs or your strategy. Please update your lawyer when these things happen so that he can see if there's a new strategy for you, if this is going to be good or bad for your case. Hopefully it's good, but if it's bad, then you can maybe, change something with USCIS, update USCIS, file for something else, or supplement whatever is currently pending or amend it. For some applications or petitions, you might have an obligation to let USCIS know of any changes in your life, but that depends. And again, a good lawyer will know whether or not you have an obligation to update USCIS of any life changes.
What if I move?
If you move addresses, you have to let USCIS know right away. There is a form that you need to file. Do it as soon as possible, because again, if you get these requests for evidence or notice of intent to deny and you miss it, then you don't respond to it. And if you don't respond to it, your application or petition could be denied.
Mm-hmm. So what if I want to go back to my home?
So let's say you just want to give up on your application or your petition, and you just leave the country. First of all, if you leave the country in general, anything pending with USCIS might be deemed abandoned. And that means USCIS thinks you're giving up on it, so they're just going to deny it. So unless it's really important that you have to leave the country, and unless you're really willing to abandon that application, and you're willing to risk not being able to come back, you're really giving up, then you shouldn't just go back home. Okay, you should let your lawyer know and see what the consequences are of leaving the country, because they could be pretty final and they could be bad for your case. Even if you abandon an application, it still stays on your USCIS record.
I just withdraw my application?
Yeah, you can, but withdrawing is done only in very rare and specific circumstances. It's not straightforward. You don't want to waste your time and the money that you invested in your application and the opportunity also, especially with these delays. If you restart, then you're starting at the back of the line, and that's going to be a really long delay, right? So you only withdraw maybe if you're really sure that you don't want to move forward or something changed in your strategy. Consult with your lawyer. Don't just say, I'm going to withdraw, or don't withdraw it on your own with USCIS, because there are steps to do that. It's not that straightforward, and there are consequences to this decision.
Can I sue USCIS to decide my case sooner?
Yeah, so this is the mandamus that we were talking about earlier. You can sue for mandamus against USCIS if your case is beyond the processing time, and a mandamus is a federal court case. And it's pretty serious. We had a YouTube video about this that takes you through the step-by-step of what a mandamus is and the advantages to that. But if you're successful, even though it's a very serious federal court case, if you're successful in a matter of months, you might get a decision on your case. So if this is something that you're thinking about, you can consult with us. You can check our YouTube video for more details on that. But the answer is yes.
Can I work when waiting?
That depends too. If you have, again, a pending asylum, a pending adjustment of status, a pending cancellation of removal, you might be able to apply for an EAD card that allows you to work while USCIS is deciding your case. This is a separate application. You have to wait for your EAD before you actually start working. Without an EAD, you are unauthorized to work.
What about if my case is with AAO? What do I need to do?
If your case is with the AAO or it's under an appeal, you filed an appeal or a motion to reopen or reconsider your USCIS denial, for example, changes in your circumstances might impact your appeal. Not always, maybe not directly, but let your lawyer know because it could still change your strategy, change your eligibility for relief. And that might be something that your lawyer might decide to let AAO know or let USCIS know, update them, and that might change the outcome of your case. It's hard to determine, but again, what to keep in mind is anything that changes in your life that is a little bit major, let your lawyer know. Obviously, if you move, you should let them know also.
Yes, and those actual time you can get yourself ready and get your case ready. And you should always check in with your lawyer for any change in your life, even though good or bad. You should just let your lawyer know.
Yes.
Mandatement is always an option with USCIS, of course. If you have more questions, feel free to leave your question to us with any of our platforms.
That's right. And aside from leaving questions, of course, you can consult with us. Our YouTube show is not legal advice. It's not advice specific to anyone's case, and it's not legal representation. It's based on my legal opinion and experience. But if you want legal advice specific to your case or maybe your family member, and if you want us to represent you, please feel free to call us to set up a consultation.
And you can continue to follow us on YouTube. Thank you. See you next time.
Bye.